So Don and I have been talking about this conference for quite a while, since last summer was, I think, the first time you mentioned it to me. But when
Since I arrived, actually,
14 years ago. But when 2 weeks ago, Don said, "And will you give a paper?" I realized that I had been the victim of an agenda-setting situation where I agreed that A was better than B and B was better than C, and C all of a sudden, anyway, here I am. I haven't worked in the formal end of social choice. Well, I sort of dabble in it every so often, but I haven't looked at it in a while. And actually, over the last 2 weeks, I've been reading quite a bit, and it has been really interesting, and I've had a very good time, so I have to thank you for putting me in this position. Okay, so thinking about social choice in law, I realized when I was looking at this that I have to start with collective goods, which I would say is the point of both social choice and public law, which is kind of where I'm focusing, although maybe we can broaden that. That is to say, goods or policies provided to a collectivity. Now, we know, and this is sort of long-standing in economics, that rational individuals have trouble with collective action, that there's free riding, and sometimes people want someone else to do the heavy lifting. There may be transaction costs so that it's too expensive to organize collective action. And one of the things that comes out of this, for those of us, I guess, who aren't at George Mason, is there's an argument for formal institutions to provide collective goods. But, and here's where I see social choice coming in, when the members of this collectivity don't necessarily agree on what the best outcome is, aggregating preferences is hard. So this is sort of how I would move into collective choice. This is what I see as really interesting about social choice. Not merely that we're trying to make social choices, but that we may disagree fundamentally about what that choice should be. And so Arrow's theorem, of course, raises its head. And there's many versions of that. I'm going to risk an approximation with this audience, and I'm going out on a limb here. But let me describe it this way for purposes of this discussion. That if we want to have some kind of symmetric treatment of relevant individuals who have heterogeneous preferences, then we can't simultaneously have a complete ranking of alternatives, the ranking being based on preferences of the individuals, no dictator, including no dictator for a day, and when unanimity prevails, when it exists. I studied social choice with Charlie, so I hope I got that right. More or less. Okay, but the point is that Arrow showed, I would say, that there are intrinsic limits on group decision making when you have diverse preferences. So what comes out of this? Well, maybe the best known is Condorcet's paradox, that under majority rule, the decision will cycle through choices, or alternatively, the decision is intransitive. The strength of Arrow, though, of course, is that any aggregation method has problems, and since this is Don's conference, I have to rag on the board account for a while. Our department, by the way, has completely moved over to board accounts since Don joined the faculty. And some of us fight a rearguard action, but to no avail. And an issue that comes up there is that the decision is going to depend very much on what the choice set is. That is to say, technically, it's not going to be independent of irrelevant alternatives. So what do we expect out of this? Well, one would be a lack of stability in outcomes. If you're talking about collective action, you would expect that there's going to be trouble because a decision might come up and then something else might come up, and we're just not sure where we're going with this. The second is commitment issues. And here, this is something economists talk about a great deal, about the difficulty that issues of commitment have for public policy. And mostly what we're talking about is that individuals will abrogate, that they'll make a commitment to do something and then they won't follow through on it for one reason or another. That it might even be it might look good before the fact and then look bad after the fact. The interest that I see in commitment here is more as an institutional matter, that an institution is going to have trouble making a commitment. Because even if really nothing changes, if there's some subtle shift, in the nature of the decision process and the nature of the set that they're considering, that the outcome may in fact change. So it's a collectivity that can't commit rather than an individual. Now, in 1982, William Riker published this book, Liberalism Against Populism, that you're all probably quite familiar with. And applying social choice to political theory, he concludes that populism is really an empty political concept because there's no way that we can describe a group in such a context-free manner coming up with decisions, that this isn't going to mean anything. In effect, that social choice undermines this notion that you can have a populist choice. Now, he wasn't complaining or claiming that we have a populist government, but he nevertheless trolled the history of the United States, searching for examples of intransitive behavior enabled by heterogeneity. And he comes up with the Powell Amendment. Okay, so this was a series of votes that was taken in the 1950s. On an education bill, and what Powell kept doing was sticking amendments in it so that the bill would fail. And the claim that Riker made was that Bill A could have passed, Bill A with the amendment also passes, and then the bill fails. There's actually a lot of controversy. I realized when I was looking this up last week, this is disputed, even that piece of history. So basically what we have is this attempt to find intransitivities in the American political system. There's one prime example, and there's a huge literature about why this is a bad example. True, we lost votes by adding the anti-discrimination amendment, but how many votes would have been lost if he hadn't added? Anyway, it's the details of it. But the point is, it's really hard, actually, to find examples of the Condorcet paradox in what appears to be a majority rule institution. And this motivated, I would say, an enormous amount of work among, well, mostly political scientists, from what I can see. It may be in the legal literature as well, about why. So, for example, Farber and Fricke, two lawyers, in 1991 wrote this piece contending that actual political institutions will resolve cycles. And I think of this as kind of the Chicago view of the world. That is, there's no $20 bill lying there because it wouldn't be lying there if it was there, okay? So the fact that we observe a political institution must mean that it can make decisions and must mean that it can get over some of these cycles. I don't know whether, I think that that's a strong statement. And from my perspective, I mostly study energy policy these days. I'm not sure that we don't have a lot of commitment problems and difficulties that in fact come up. But in this formal sense, what this, I would say, combination of issues brings us to do is to really focus on what components of the institutions yield stability. We're not going to be able to say what components of the institution give us a result. We're not going to be able to look at the voting procedure and say this is going to give us A or B. But it is interesting to look and say, how is it that it gets around the kinds of social choice issues that we would expect would arise? And so we have a generation, at least, of people who've studied collective institutions, largely in the United States is what I'm aware of, and considered how it is that either the set of issues has been narrowed, things like the dimensionality has been reduced, say, by the structure of committees in the House. Ken Shepsley wrote about this. How the people who get to participate in any given situation is reduced. Limits in one way or another. Who gets, or if you don't have the limits, who it is that's getting to choose, who has agenda power in a particular situation. And we've seen applications of this to the structure of the legislature, to the analyses of political parties and how they help with trying to reduce intransitivities, trying to limit the extent of Condorcet paradoxes. To interest groups, this was actually an area that I wasn't familiar with until I started looking it up a couple weeks ago. But the idea, I mean, the old view of interest groups, this Olson or whatever, would be that we expect interest groups to form when they're small, and that therefore small groups of very intense, this is transaction costs, that a small group might form and thereby influence politics more than a large group. And what has been pointed out is that that's sort of nonsense. This is a theory that's full of holes. There's these huge groups. There's environmental movements. How is it that people with apparently small stakes can prevail? And looking at it from the social choice perspective, we wouldn't necessarily look at the number or these sort of traditional transaction costs, but rather, is this a group that's managed to limit dimensionality? And certainly in something like the environmental movement, you find this. So there's a different perspective to think about the stability and formation of political actors. Some particularly, again, I'm going to say in economics, this is what I know about, and I don't want to limit this. There's been this new movement, the so-called new institutional movement, where instead of trying to just look at the formal rules in politics, electoral rules, things of this nature, people have gone beyond that and looked at things like norm, culture, informal institutions as a source of stability in situations where we otherwise might not have it. Now, what occurred to me as I was looking at this and going through this literature is that courts have escaped, as far as I can see, much of the scrutiny of the social choice view. And I hope to be corrected in this by tomorrow. But people tend to look at the courts as a solution rather than part of the problem. I would have to describe it that way. That you have things like jury issues, but then there's the judge that's making things work right, okay? But it seemed that there's a number of interesting issues that come up when you think of the courts as another collective decision-making process, and the fact that they must have institutions as well that allow for these kinds of social choice issues to be avoided. Maybe things like, how does the Supreme Court allegedly controls its own agenda? Does it really? Do we see other mechanisms that try to limit, and can we make sense of the way that they make choices as a mechanism to try to limit Condorcet problems or other problems in collective choice at that level. If we think of, there's a literature about externalities that come out of lawsuits, but usually this is just costs imposed on other plaintiffs. What if the plaintiffs actually disagree? What would that mean about the order of suits that come up? Thinking about precedent, not as a commitment mechanism by the court, but rather potentially as another mechanism to avoid intransitivity. So this struck me as an area where I just hadn't seen much written, and I would be very interested in hearing more about it. Excuse me?
You got a lot of time.
Oh, does anyone want to talk then? This is sort of where I got to in thinking about this.
Well, let's open up a discussion. People have comments on this? Charlie, you must have something.
Well, I was thinking about it. These are super deep questions. But so, I guess when you first started out, I was thinking, well, if you want stability, right? You don't want a seeming. Is it the case that you feel that the courts and other people are worried about the seeming inconsistency? And if you're worried about seeming inconsistency, there's a very easy way to avoid that. That's maintain the status quo. So if you have a default in there, just a default, it's pretty hard to develop a path that leads back to where you were, right? Because when you get back to the choice of where you were and where you are now, we basically, the rules say we've considered that, choose a default. In fact, we use a default a lot when we're trying to manipulate groups, which is a little different issue.
Mm-hmm.
So, I don't know, I'd forgotten all about the Riker point of view.
He spent 300 pages looking for intransitive votes and found one, as far as I can see.
Max? Yeah?
So the court's question I'm actually going to be talking about.
Oh,
so
great.
maybe it will answer some of the open field questions that you have. We'll see whether I satisfy you that any of my answers are right, but I'm sure I'll satisfy you that I've tried to answer at least some of it. I guess the question is, I want to go back to the Farber and Fricke comment for a moment, that you made the observation, or you repeated their observation, that institutional mechanisms within the legislature break cycles. I guess I want to push back against that slightly. And I also want to push back against the notion that the absence of evidence, and you didn't say this, might be evidence of absence. Because I think those 2 points are related. And focus specifically on the nature of congressional, or not just congressional, but legislative decision making as an institution. And one of the things that characterizes legislative bodies is the ability to remain inert and just not do anything, which relates to Charlie's point about status quo bias. But the point that I'm trying to make is that the manifestation of cycling might be inaction. In other words, the very non-observability might actually mean that the institutional mechanism is one whereby there are different ways to avoid choice. And one way to avoid choice is direct conflict. You may, for example, have a majoritarian preference on one side of the matter, but have substantial minority pushback. You may make a collective judgment, it's not worth it. It's not worth having 60% be satisfied to the upset of the other 40, because we're in a game that's going to continue. In future rounds, that 40 may gang up with another group, and if we do this in this kind of zero-sum way, that the payoffs, it would be a myopic approach to decision making to always be in narrow majorities. But the other way that you could achieve inertia is because you discover that there isn't a collective will to actually satisfy an outcome based on a criterion like Condorcet. So I'm not, in other words, it may be the case that you discover in the course of your negotiations that in fact you've got a lot of people who want to change from the status quo, but they don't aggregate around a particular method of change. So you've got multiple proposals, and because you've got multiple proposals, there are many dimensions along which they can be assessed, and there are cycles. There isn't a Condorcet winner there. And so the inertia might be the manifestation of the cycle. So in other words, it's not obvious to me that the failure to see it means that you're not actually, in scare quotes, observing it. And it's more of a comment. I don't have a question mark at the end of it, but I just wonder what your thoughts are.
But it does sort of suggest then that, taking as a specific example Congress, because this has been analyzed a great deal. So we have all of these committees, and we have these people who allegedly are setting the agenda, and we have parties who should be able to do that, right? And yet, there's more to the structure than just these pieces, the jigsaw puzzle, as Ken Shepsley would say, right? Because they don't. So maybe this gets beyond it, that they're not, or like you said, maybe it's the myopia is being trumped by the view that these people are around a long time. This is why I was interested. This is one reason, by the way, we were interested in term limits 20 years ago, right? As a possibility that would, if this was important, then something like term limits would presumably lead to a real breakdown in one side or another of that argument.
Yeah, just to put a few other possibilities on the table, right, on how social choice and law can be related. I mean, there is, of course, the voting idea, right, that we see within law, as you say, as much as within political institutions. But of course, it's there's just decision making, right, and so it would be of some interest, I think, to us as lawyers or as legal theorists who think about what it is to construct a coherent body of law over time, right? Or to develop a rule for a set of cases, right? Whether the notion that, you know, brings an ordering to that is the same notion that is the notion, technically, the notion of ordering within, you know, rational choice, right? I'm guessing that it might not be.
With
right?
the implication that it could come out very differently,
Yeah.
right? Depending on the order
Well,
that
of
the
course,
law
and
is
so
approached
one
in.
story might be, given that it's a sequence of decisions
Mhm.
that come at you in some sense, not as a, you know, the judge doesn't get to call the case,
Mhm.
right? The case comes kind of randomly from the litigants. It might be thought that this will be a result that's entirely path dependent or something. That may be thought to be problematic or not. I have no idea really whether that's thought to be problematic.
Well, there is, I mean, I'm sorry.
But I think more just generally the idea about what it is, for example, to work with a rule and yet allow the rule to be adjusted in the context of cases, which is clearly what lawyers think about or legal theorists think about all the time. Like, what is it that we're actually doing there? When rules seem to have some bearing upon a case and yet are not applied deductively within it, that is, they're subject to adjustment as the case comes up. What is that process of aggregation over cases? What is that really? What kind of rational?
What are we actually getting out of this? This is
I think
why it
that's
seems that there's a
There's
social
broader
choice issue that could
decision-making
come in there.
aggregation idea that we're interested in, I think.
Because there is actually some, I mean, I've seen evidence of strategic behavior in that context.
Of course, yeah.
The federal government not appealing cases that they think they might lose, things of this nature. So, as I would mention, the Supreme Court doesn't have the sort of agenda power that they might, that sometimes is credited to them. Given that they do, then there's a much more complex situation.
The other situation that arises is, I think, even not across cases as they develop a coherent body of law or a rule for the cases or whatever it might be, there's also, I think, within a case, right, a highly structured set of decisions that are made within the case, a sequence set of decisions that, again, may or may not reflect something rational, right? And again, you know, with
And-
social choice theory, something contributing to an understanding of what a proper sequence would look like.
Large number of, I'll come to you next, but I want to say Thomas McEntee is, on his thesis, is coming up with a large number of new probability distributions to look at the likelihood of, you know, because we usually have just one or two in the literature of looking at when cycles can occur. And he finds that in cycles for 3 alternatives, it's 1 out of 16, and maybe a little bit larger with one of the others.
From 1 in 16 to slightly under 1 in 11.
Okay, 1 in 11, which means you shouldn't expect to see too many. And second, too many cycles, you know, 1 out of 16.
Who says things are random, though?
Well, even if they, and secondly, there are a large number of examples which we now know, which are conclusively cycles. And the third thing is that we have certain rules getting into the path dependency. If you have path dependency, you have something like a cycle. That you can prove. And what happens is, with Robert's rules of order, you can't go back and compare. So if I find B is better than C, and A is better than B, I can't go back and compare A and C type thing. And so what you have is there's, by Robert's rules of order, etc., a lot of things that might be cycles, we don't know if they're cycles, because we can't make the last comparison, which would be necessary on there. You have a comment?
I was just going to add that since she had mentioned tournament, I think the issue behind that is money and politics, that when you vote these people in, they're supposed to represent the will of the people. But because of money, sometimes they're voting on things that aren't really, if you make rational choice, would be for example, education should be for the benefit of the students. Or, you know, so I think this may be one of the things I think you have tournament, that's sort of a short-term fix. I think the long-term fix is really transparency and accountability to stakeholders, that whoever's elected need to be to have that, so that you're aware of the money that's being influenced and their action, and so that the people that vote them in can have some control of that. Because I mean, term limit is one sort of short term, but I think the long term is having that consistent transparency, accountability, and regular feedback by the stakeholders that's really impacted. Because amazingly, there's very little feedback to provide a control mechanism. Problem most people, I mean, engineering system get better with feedback. There's very little feedback in a lot of our social systems.
Sure.
Well, I was just gonna,
Okay, him, and then I'll get you next week.
It's probably been 15 years since I read the Farber and Fricke book, but my
I
sense
wasn't
is-
born yet.
And I had a week to go over it, so I'm on top of it.
My recollection is the book presents interest group theory or pluralism, whatever you want to call it, and social choice as two branches of the same tree. And yet,
Yes.
there's,
But
as
they're-
you described, they don't talk to each other. And one of the things I think that's interesting is that the interest group theory has been very influential in the law. So we have all kinds of theories about whether we should interpret statutes in a public regarding way because there's going to be capture and rent seeking and all these bad things going on. We trust courts to police that. And you kind
Yes.
of gave an indication of that. But social choice seems to have had minimal to no impact on the courts.
We're
Now,
trying
I'm
to
not
change
saying
that here.
Max talks a lot about how the courts are victims of cycles and all that, but I'm talking about courts citing this stuff as
So
a
this
reason
is-
for interpreting statutes.
This is like the McNulgast effort. Is that kind of where you're going? That, I mean, they had this whole structure of trying to take a decision, unwrap the social choice pieces to find legislative intent. And I mean, I start out saying this is an exercise in futility because I don't think there is intent, and that's where we start. And I mean, if you genuinely believe in heterogeneity, and you're comfortable without having an equilibrium, then it doesn't make any sense to even go down that path. But that certainly was what I think this is not a mischaracterization of what the agenda was, and that's the papers, was trying to figure out how to deduce, how to infer a so-called legislative intent out of the nature of the amendments and the bills and so on. And yeah, I would agree. I don't see it being very,
Very between institutions.
yeah.
You know, there's a lot of that in Eskridge and Farrajohn's work, rather than decision-making within institutions.
Charlie?
well, I was just going to add, in terms of cycles, you know, if there's a blocking coalition, that's somebody who's in all winning coalitions, so you can't do anything without, you can do things, but you have to have this person's agreement, like a department chairman, someone you might know. Or somebody who has
What?
power to block the consideration of a motion, like a rules committee. If you have these kinds of players in the game, the core always exists. There will be no cycles, which is very closely related to Don's observation that if it's path dependent, you're not going to get a lawsuit. That's a kind of structure.
So this is,
There. So the institutions can prevent this kind of seeming arbitrary. A subtle arbitrariness is still going to be there, but the blatant cycles, those can be eliminated by institutions very
Yes.
subtly.
at any point in time.
What's that?
At any point in time, because then you have to worry about who's
Oh,
in
I
that
understand.
position.
Yeah, I understand that.
Bill?
Yeah, I mean, I agree with you, Linda. The natural question to ask is if there are if social choice theory says these cycles ought to arise, ought to abound, why don't they, jump out at us, and why did Riker have such difficulty establishing one convincing case? But I think Max has it right that it may be that we are just looking for too narrow a range of evidence. I mean, think of the counterpart in the individual case. Do individuals exhibit cycles? First glance, they don't jump out at us, and people seem reasonably consistent. Hence the appeal of the standard economic model. Then there's all this new behavioral economics, which isn't ordinarily particularly interpreted as an example of cycles, but easily could be thought of as instances of multi-criterial decision-making resulting in cycles. It's not the usual take on it, but I don't think it's an implausible way of interpreting it. And similarly, I wonder whether all sorts of many of the things that one casually labels as seeming irrationalities in collective decisions and parliamentary decisions, not of the cycling variety, could in fact be easily viewed that way. They're not cycles of such an emblematic and straightforward fashion as the Powell Amendment that Riker talks about. But just like the Tversky-Kahneman experiments, which are not presented as experiments of cycles, but could easily be interpreted as that, my hunch is that there's lots of the sort of stuff that gets decried as irrationalities in public decision making that invites that take, though it's not usually how it's seen.
I guess I would add to that, I agree with you. I would add to that some of the institutional mechanisms, if I can tie this in with what Charlie was saying, may be part and parcel of the same. So as much as we dislike the idea that there's going to be the powerful committee chair, or that some set of people don't have standing in a case, or that the court has narrowed the issues that we're going to be deciding over in any given case, that all of those could be manifestations, as it were, of underlying heterogeneity in beliefs and preferences, because that's where that's what I would focus on underneath this, is that we have to have some way of dealing with the fact that people don't agree about what should come out. And if we're trying to find truth, then it's a different story. Then we can think about a mechanism that's efficient. In many of these cases, there isn't necessarily one. And then we're looking at other phenomena.
Homie? No comment? Robert?
It's a fascinating subject, and as a layman, I look at this, having read just layman versions of these interpretations, but looking at social choice and on the influence of one on the other, you think, my friends that are practicing lawyers admit freely that, look, Supreme Court judges are human beings. They're subject to their own biases in that of society. And if, for example, you look at civil rights legislation after Reconstruction, you see, at least in my terms, a cycle of opinion really focusing on societal zeitgeist, populism, that sort of reversed civil rights for blacks in particular, and then of course after Johnson and so on, all of that turned the other way. But again, it shows how complex precedents can be and how they can lead to mathematical chaos, just sort of random behavior. And so you've got this potential inconsistency with that decision reflecting social choice. If you look at interpretations of how corporations came to be defined as people, you hear stories of whatever the Southern Railway and tax decisions that were made in the early 19th century that got gamed somehow, we're told, into giving corporations sort of person-like tax rates, and how that muted into, now this may be apocryphal, you'll have to set it straight, but the notion that a corporation now, with all its power, gets defined virtually as a citizen by Supreme Court judges that understand the words, all men are created equal, are they corporations? These are inconsistencies that seem to reflect a very interesting turn, both precedent, the complexity of precedents taken together as aggregations. Please comment on these issues, because they seem to me as good examples of these problems.
I'm going to try to duck this by asking Rick to comment.
I'm not sure that.
Or Max was.
One small observation, because just by coincidence, this past week, I stumbled across this. I teach constitutional law, and stumbled across this. Somebody pointed out to me that in that Southern Pacific case that declared corporations to be persons, it was actually a reporter who put it in a head note, even though it wasn't in the case. In that head note, so for those of you who aren't lawyers, the reporters for the case, when these cases get reported, they put these head notes that actually talk about what the case is about and use it for a coding system. So the reporter put in the head note of this 1870s case that the opinion said that corporations are persons, but the opinion itself nowhere mentions it. And it is known. There's about 8 law review articles that talk about this. And it got cited multiple times in successive cases, even though it was just the court reporter mistakenly sticking into a head note So anyways, so you talk about arbitrariness.
And this is
That
how a
would-
body of law is formed.
That might be-
Judges
that might
are
be,
completely out
that
of
might be
it.
the exception that proves the rule, and the rule proves the exception. I'm just saying, that is as anomalous as it gets, and I only stumbled across that quite by accident this past week.
But did you hear that same court reporter was moonlighting for the Southern Pacific
I
Railroad?
don't, it's very possible.
So,
We're gonna have to move on. Robert. You're gonna
This
get,
story is getting better and
as
better.
always, Robert, you're gonna get us going in another direction. But we got time to move on, so I want to thank Linda right here. And grab yourself a cup of coffee while Max is setting up here.